Constitutional Court has exclusive jurisdiction over certain disputes, and these disputes are ones where no other court has the competency to adjudicate on them. The Constitutional Court has exclusive jurisdiction over matters that are contained in Section 167 of the Constitution. So, these are disputes between organs of state in the national or provincial spheres, and also the determination on the power, status, and functions of those organs of state. The Constitution is also settled with the responsibility of adjudicating on whether or not bills of parliament hold up to constitutional muster. This can be national or provincial parliaments. So if Parliament creates a bill and they are not sure whether or not the bill is constitutional, or the executive is not sure that the bill is constitutional before signing it and passing it into law, it can be sent to the Constitutional Court for final adjudication. This is very similar to the processes that were taken in the first and second certification judgments. So if you refer back to what you learned when you were doing constitutional law for your LLB, you will have remembered that the first and second certification judgments certified whether or not the constitutions themselves, the interim and the final constitutions, were constitutional. Now, I know this is a very weird circular way of thinking, but we go back to the guiding principles of the Constitution being a non-racial, non-sexist society that is open and democratic, and take dignity as a prevailing feature. Then we look at the first and second certification judgment, and that's how it is created. Now, new bills can be taken to the Constitutional Court to look at the bill in comparison to the Constitution and see whether or not it fails in any respect in terms of the Constitution. Another place where the Constitutional Court has exclusive jurisdiction is when there is an issue with regards to a province wanting to create their own constitutions. Now, this has been done really only once, and that was with the Western Cape, who drafted their own constitution, and the Constitutional Court had to certify it. So the Constitutional Court also has a sort of pseudo-exclusive jurisdiction when it comes to whether or not an act has a provision that must be struck. So, if somebody brings an application to the High Court to have a certain provision struck from an act because that provision is unconstitutional, the High Court, if it finds that that section is constitutionally invalid, it must strike it, and then that goes to the Constitutional Court directly, bypassing the Supreme Court of Appeal for what's called a confirmation judgment. If you want to follow this sort of in real time, an organization called Blind South Africa, Blind SA, brought an application to the Pretoria High Court to have certain sections of the Copyright Act declared unconstitutional because they led to an infringement of blind people's rights to access certain types of literature because it wasn't available in a format that they needed. That is now going in the first half of next year, we hope, to the Constitutional Court for confirmation. So if you want to follow this in real time, you can look at the news articles surrounding Blind South Africa's litigation on the Copyright Act. So then there are times that the Constitutional Court will accept an application for a petition of direct access. This happens in extremely exceptional circumstances where there is both an element of urgency. What I mean by that is not the same as urgent court in the ordinary sense, but that if the Constitutional Court hears it first, it will save unnecessary time wasting. Second, that the matter must be of such high public importance that the Constitutional Court should hear it first. And thirdly, that there is a novel and important question of law that needs to be decided. This is all brought in terms of Rule 19 of the Constitutional Court rules. But, as I say, it's highly, highly rare. So, to recap, there is exclusive jurisdiction when there are disputes between certain organs of state. There is exclusive jurisdiction in the Constitutional Court when deciding on a bill that has been sent by Parliament or by the President for consideration before it's passed. And then there is also deciding on the constitutionality of provincial constitutions. So we go through this and we see that exclusive jurisdiction of the Constitutional Court is very rare. And then there is also when the Constitutional Court has the discretion to allow direct access. Just going back to the direct access question, during COVID, the early stages of the hard lockdown of COVID, there were many political parties and civil society organizations that petitioned for direct access to the Constitutional Court about the national state of disaster. The Constitutional Court rejected each and every one of those petitions for direct access. When we look at petitions for direct access, we look at that have been successful, that are in recent memory, we can look at the Zuma contempt of court matter. Now the novel question that the Constitutional Court had to answer in that contempt of court and the application to compel that the contempt of court came from was whether or not a former president who had called for a commission of inquiry, created the terms of reference and signed the commission of inquiry into law, whether or not that president was able to disregard the rules of that commission of inquiry. As we know, Zuma ignored the order of the Constitutional Court, which said that he was compelled to remain bound by the rules of the Commission of Inquiry. When he failed to appear as the court had ordered, a civil contempt application was brought, and the civil contempt question was whether or not somebody can willfully, intentionally, and maliciously disregard an order of the Constitutional Court. I know there were a lot of arguments made about the Audi Alteram Partem rule and in terms of somebody's right to a fair trial and for that to be appealed. But the Audi rule, the right to be heard, was disregarded by Zuma's legal team because he refused to file an affidavit in defense of himself in the contempt application. And furthermore, the civil contempt has been seen to be constitutional as a constitutional concept in the PECO judgment, which is a former application for contempt of court. That judgment, you can read it, was penned by Sisi Kempepe. And the rules of civil contempt have been long-standing in our jurisprudence and have never been challenged on constitutional grounds. They have been challenged, but they've lost. So we can see a long and very rich history around contempt of court applications. And had this not been the Constitutional Court, it wouldn't be different. So I think that the petitioning for direct access in that case was very poignant because it examined a question of law that hadn't been answered before. So the jurisdiction of the Constitutional Court in terms of direct access and exclusive jurisdiction is quite settled in our law.